Hello, everybody, and welcome to For AP Council's webinar, License Your Valuable Assets. My name is Claudia Tapia. I'm the chairperson for AP Council and will be your host today alongside Dana Colarulli, Executive Director of Licensing Executive Society. Next slide, please. As you may know, For AP Council is a not-for-profit research council developing high-quality academic insights on topics related to intellectual property and innovation. Today's webinar is the third in a series with LESI and has been marketed with the European IP Help Desk, who I would like to thank for their support. For AP Council offers an extensive body of detailed research addressing current IP and innovation themes. We also conduct education activities, including the creation of resources to encourage innovative SMEs to grow their businesses using IP. Please visit our website for a range of free materials. These slides and a recording for this webinar will be made available on our website tomorrow. And for today's webinar, if you have any questions for the speakers, please post them only in the Q&A area on your screen. This way we can make sure we collect them and raise them to these amazing speakers we have today. So without further delay, Dana, the floor is all yours.
Thank you so much, Claudia. Happy to join you all today. Again, as Claudia said, on our last of our series of 3 webinars on these LESI publications that we published last May. I am, as Claudia said, Dana Colarulli. I'm the Executive Director of LESI. Very excited to join with 4IPC to do these webinars. I think they've been really extremely well received, and I think we're ending off in a bang on one of the most important issues, and really talking through how you structure these licenses and walk you through this publication. So I certainly encourage everyone to read the publication in full, but I'm excited to get to our discussion today. I'm a US-based attorney. I've spent most of my career on IP rights in the government and the private sector, talking about a lot of the issues that we're talking today. I'd like to tell you a little bit about LESI first, and we have a slide up before we get into our discussion. LESI is an umbrella association of 33 national and regional member societies across the world. We're in more than 90 countries, serving more than 7,000 individuals. Our mission is to advance the business of IP, and hopefully we're doing that today with all of you. We believe in the value of IP as an enabler to drive today's innovative technology to the marketplace. We do this in a variety of ways, including through meetings, networking opportunities, publications, and engaging the public and private entities in agreements to further education and to further discussion around the cutting edge of licensing. We're also currently planning our annual conference for next May. I hope many of you will join us. We would have loved to do it in person. We've decided to do it virtually, and we're looking at a very innovative way to structure it as well. So more coming out about that, but it'll happen the end of May 2021, and we'll be talking more about a lot of these issues. So without further ado, this session is on the third of 3 publications, 3 business briefings. This one's License Your Valuable Assets. It's written specifically for SMEs, but really I think very useful for all. For those involved in writing these publications, they're experts in their field, but the idea was to try to break this down into a smaller publication that really could be very widely used. They're all experts in their area, but we've been over the last few months using them to further conversations within LES. Happy to be here today to further that conversation here. The 2 speakers that we have are going to lead us through the discussion. Eszter is an attorney at law at Dambui Legal in Budapest. And Anke is managing director and partner at Valens Corporate Finance in Germany. So she comes at this from the economist side. Between the 2 of them, I'm looking forward to them leading us through the publication. And I'm going to ask you both a number of questions so we can really kind of get into the topic area. So with that, Eszter, I'm going to turn it to you to kick us off, and the floor is yours.
Thanks, Dana. So what we are about to do with Anke, and let me also welcome everyone and thank for the organizers for the invitation. What we are about to do is that we are going to guide you a bit through of the content of this LESI briefing that Dana has just introduced, licensing your valuable assets. And next slide, please, Dana, for the content. So I'm going to do the first part A, and I'm going to cover a few essential and legal notions related to license agreements. What is a license at all and why we need them, how we prepare for a license agreement, the main types of license agreement and the nuts and bolts, the most essential parts of them, and some further more specific legal considerations. Then I'm going to hand over to Anke, and she's going to talk in more detail about the financial specifics and outcome of the license agreements, the royalty rates specifically, and provide a more economical and financial perspective on all these things. Next slide, please. So first of all, what is an IP license? The IP license is the permission granted by the licensor to the licensee to use the specified intangible assets under agreed conditions. In other words, if somebody has an exclusive IP right, that's the licensor, and they allow someone else, the licensee, to use that right, and they agree on the terms and conditions of that use. They make a contract on it. What IP rights can be the subject of the IP license agreement? Well, all of them. What we really hear every day is license agreements on patents, trademark, copyright, but you may even think of know-how licensing, which is very common, unregistered and registered designs, or even databases. You can make a single IP the subject of your license agreement. You can license just one right, but in real life, it's very common that multiple rights are licensed in the same agreement. For instance, trademarks, patents, know-how related to a product that has a patent on it, which has a know-how related to its manufacturer, which already has a trademark. So the possibilities are really endless. And the first question is, why should we license? Why is it good for? So if you have an IP right and you are thinking about licensing, there are a few things to consider, pros and cons. First of all, as a pro for the licensor, the licensing will generate cash flow for you. You will receive revenue out of the royalties. That's obvious. Also, it allows a geographical expansion for your IP. What I mean by that is like a few years back, my firm had a client. It was a middle-sized, basically family-owned Hungarian company active in the field of food processing. They were dealing with eggs, actually. And they had technology they developed. They had a patent on it. And that was a pretty good one, a solid patent, really. But they were not interested, just not motivated, actually, to take the technology themselves to other territories. For instance, they didn't want to build a factory or hire factories. What they wanted is licensing the IP so that they have good licensing partners in all those territories where they have protection. And that's what they did. And that actually brings us to another pro, which is that if you license the IP right, all the investment and the risk relating to creating that infrastructure, the logistics, to commercialize the IP is not on you, it's on the licensee. But of course, there are some cons as well. If you think about the previous example with the food processing company, they created their very own competition by licensing, actually, because had they changed their minds and decided to go on a certain market themselves, they would have no longer be the first one because they had already licensed that right. Very often it occurs that it's difficult to monitor license agreements for licensors, difficult to monitor if the licensee indeed abides the license agreement, if it complies with it, but also the revenue basis of the royalty. And thirdly, what you have to face and think is that by licensing your IP, you actually, in a way, lose control of it. A bunch of business decisions will no longer be made by you. How you use that IP, how you treat customers, these things will no longer be in your hands, but in the licensees. And equally, a lot of information from the market will not come to you in the first place, but to the licensee. To a certain extent, I think this can be regulated in a good agreement. Next slide, please, Dana. So if you decide to license, what are the things that you should think before you're actually entering one? First of all, you have to be able to find your IP. What I mean by that is that you have to identify your IP. You have to be able to present it when you are dealing with others. This might be easy and actually obvious when you're licensing just one right, but in real life, you tend to license more of them and a variety of them actually. The other thing that you have to be sure that legally you are in the position to license that right, that you have the right to license and nobody else can prevent you from that. So you have to check third-party rights to that license, to that IP. Then you need to find a partner. When you're actively looking for a licensee, I believe this is mostly a business decision and probably life presents the candidates, but there are certain things you might want to check. For instance, the licensee's market power and expertise. This food company, we had once, they were kind of safety players and they were looking for solid market players, those who have already established their names on the market, who had good distribution channels, who presented no risk. This brings us to another thing, financial stability, because it's important because you're going to be there in that licensing agreement for the long term. You might want to think about if you want someone big and strong with less risks, but maybe outpowering you a bit in the negotiations, or you want someone who is eager to grow and eager to use your IP, maybe a little bit less stable, but maybe can put you in a better position in terms of what you can get out of the license. So there are a lot of things to consider about the partner you are going to go with. And last but not least, you have to be very attentive that you protect your confidential information when you are starting to negotiate. And you must be very careful in disclosing your IP. Having an NDA in place is crucial. NDA is in a non-disclosure agreement. And if you do not have an NDA, you cannot be sure that the IP and the confidential information that you disclose to the party you are dealing with, that they will not use it or not disclose it further on when they are doing their business or where they are dealing with others. And if this goes sidetrack in this phase of the negotiations, you can really lose a lot, if not everything. If you just think of what happens to a patent if the patent is not yet filed and the technology leaks and goes public in course of the negotiations because the NDA is not there to protect it. So that is also a very important factor. Next slide, please. The main types of licenses, usually people say that there are 3 of them, and they are quite easy to distinguish and understand. I think one is the so-called sole license. The sole license means that the licensor grants the right to one licensee who is exclusive in this sense, but the licensor also maintains the right to exploit the IP themselves. Why this is good is that the licensor is not so dependent on the licensee. The exclusive license differs from this in the fact that even the licensor is excluded to use the IP themselves. This is a very strong position for the exclusive licensee, of course, but also one that is very common, for instance, in the pharmaceutical or life science field. And then the third type is the non-exclusive license, and that means that the licensor grants multiple licenses on the same right, and it grants it to multiple entities at the same time. Each is doable and each has a wide practice. Which one you use basically depends on the industry and your commercial purposes. Next slide, please. So now we are there and we are going to create a license agreement. So what are the nuts and bolts, the most key things to think of? And let me say, and not just because I'm a lawyer, that there are a few things that have to be laid down crystal clear and very well defined when you're making an agreement. I'm saying this because I'm mostly a litigator, and I usually meet contracts, license agreements, when the parties are no longer smiling at each other, but they are snarling over things. And I would say that leaving ambiguous definitions in a contract, in an IP license agreement, can be the source of really painful conflicts later on. And it can ultimately even bar or hinder the commercialization of that IP, which was what everybody wanted in the first place. So what are those things that you want to define very well? First of all, the licensed rights. What are the rights that you are giving license to? Again, this is simple when it's just one right, but when you are licensing all the rights related to that technology, then what is all? Do both parties mean the same thing under all? Then the same goes for the licensed product. I mean, an IP right can attach to many forms of products. Just think of a trademark. You can put it in a bowl, on a computer, or a pen, on whatever, and the licensor can control the scope of the agreement if the licensed products are well defined. Then the term and the territory of the license seem to be obvious, but sometimes can be tricky, because the term of the IP license agreement can be either a fixed term or can be renewable, but should not go beyond the lifetime of the IP right, which is again a bit tricky when you're licensing multiple and various types of IP rights. The territory is, needless to say, is crucial. You don't want to end up in conflict later on where your licensee is able and allowed to use your right. But also on the level of definitions, this is interesting. If how many IP license agreements can be out there that say that the territory is the European Union, and the European Union's territory is not the same thing before and after Brexit. So I'm just saying, be precise with the definitions. And I'm going to jump over the payments, although they are very important, because I leave it to Anke to talk about. And there are two more things. One is the sub-licensing. Sub-licensing means that the licensee has the right to pass on the license to allow others to also take a license based on the right that they acquired. And this can be controlled by the licensor, either by excluding it or tying it to their consent. And you may think that allowing sub-licensing without any kind of control or restriction is dangerous, but also think of it from that way, that if you have a licensee who has a good network and good reach with potential, then which you don't have, then you may benefit a lot from the sub-licenses. So this is something that should be carefully thought through. Infringement, why do you have to deal with infringement in the license agreement when everybody is happy? Because IP rights tend to be infringed from time to time, especially good IP rights. And when an IP right is infringed, then there are a bunch of strategic decisions to be made in connection with the protection of them, in connection with protecting the market. And that can go sideways if this is not coordinated between the licensor and the licensee. So there should be a mechanism in place. Who does what? Who enforces the patent? Who pays for that? How do they communicate? I would say that it's better to have these things put down in an agreement and spend some more time in doing them than leaving it to the applicable law. Because even though the national laws do have some kind of provisions related to these things, they may vary from country by country, so you might not be aware of it and you don't want to end up surprised. So it's safer to have these things clarified between each other. And next slide. And so lastly, this is the legal stuff you need to consider. If what I have said before wasn't legal enough, this is going to be like super legal then. But really, there are just a few things that are commonly form part of license agreements, and they are useful to think through. One being diligence obligations. What it means is that what does the licensor want? The licensor wants the licensee to make every commercially reasonable effort to really exploit that IP and not just have it laying around without any use. It sometimes goes beyond simple obligation, and sometimes goes beyond simple obligations, and sometimes there are obligations to pay minimum royalties, for instance, to motivate the licensee to fulfill them. Improvements often come up related to patent and know-how licensing, and that means that if a technology is developed by either party, either the licensor or the licensee, there can be improvements, and the question arises how they get access to those rights and how those rights may affect the royalties to be paid, how they will have access to the improvements once the term of the license expires. And I think this is where also the definitions come back, because it's important to know where your licensed technology ends and where the improvements begin. Then warranties mean that the licensor declares that certain facts hold true. Typically, there are warranty of ownership to the right and non-infringement in the sense that the licensed IP right doesn't infringe on any third party's right. Indemnities come hand in hand with that, because that means that the licensor shall compensate the licensee if there is any loss it suffers related to a third party claim based on the usage of the IP. And this is a justifiable expectation of the licensee, but very often there are like preconditions. For instance, that the licensee has to notify the licensor duly of any claim of a third party so that the licensor can do everything to protect the IP. And last but not least, there are some provisions which may seem very attractive, especially if the licensor is a powerful one, but may be contradicting unfair competition law. So this is just an angle that you should be wanting to use when you are making the agreement. And ending with the legal stuff, I think this is my last slide, and I'm going to hand over to Anke. Thank you.
Great, thank you, Eszter. So, well, now I talk to you as a fully fledged economic person. And from my point of view, in licensing situations, it always comes back to the same point, and that is, what is the economic benefit, either in the situation of licensing out or licensing in, or just like to cut the story short, it's all about money. Dana, could you switch to the next slide, please? Thank you. Well, if we start like to compare maybe the license fee with a rent in the real estate sector. Well, first, you do not own the IP, but you are allowed to use it. There are certain conditions how long you are allowed to use it. And it's agreed what you are allowed to use. In the real estate sector, the whole building, which is exclusive, or only parts of it. And the building and also IP needs to be maintained. Who is responsible for that? What are you allowed to change or to do with the building or with your IP? What do you have to invest, either by yourself or what is the landlord doing? And what are the specific value drivers in your lease relationship? Do you lease a high frequent spot in a prime location, or is it enough for your goals to use something on a more like modest level and develop it by yourself? Well, and what does this lease is doing to your competition situation in the market and also to your cost structure? And well, all these considerations you have to have in mind when you lease a building. It's quite similar what you have in your mind when you set up your economic conditions in a license situation. Well, I could continue to tell you more about these economic criteria to choose a certain location, but now we talk about the license strategy here. Nevertheless, to be honest, there is one great mismatch between the comparison of leasing a house and leasing IP. a house is quite solid, and well, you can do a lot of emphasis to get a quite good look to a feeling about the conditions and risks when using this building. IP has, and that's unfortunately always the case, totally different circumstances. IP reveals its real value in the way it is used. So the usage of IP is much more uncertain compared to a lease of a building. So this is, to be honest, much more complex. A patent portfolio, for example, has a limited lifetime, as it can only be protected for a maximum of 20 years. If you have like a complex technology and a smart patent protection strategy, you might like enlarge this time frame by applying for new patents in the same field of protection and try to prolong this period. But still, the time to extract the economic benefit from the usage of the patents is limited. You do not have much time. And this is a very critical factor from an economic point of view. So you have to make great investments in order to put the IP as fast as you can in a situation where you can use it, and that creates a real cash flow. In a building, you just move in. Maybe you have to do some like renovations, but the risks are limited. So to be honest, the idea to compare IP licenses with a rent of building is nice and gives us some guidelines. That is not just plugging a royalty rate in a contract. And this is what I really want to discuss here in this webinar. And that's also one point in our business primer. Finding the right economic license condition is a quite complex issue. Well, let us talk about the different types of, this is the point you see here on my, Dana, can you, I think you, which slide are you on? Yeah, sorry. Yeah, it's, this one. I was just confused because it was one further. So we have to talk about the different types of license fees, the one issue that Eszter referred to. Usually, most of the people I talk to think about a running royalty when they talk about a license fee. But this is only half of the truth. A license fee can be agreed in very different ways. First, there's a very typical like fixed fee you could use. This means a license fee is a fixed amount that has to be paid by the licensee, either as a one-off amount in the beginning of the license agreement, or also as a fixed fee to be paid, like for example, each year of the duration of the agreement. Another possibility is to agree on a royalty. Royalty means that dependent on the result of the usage of the IP, the licensee pays a certain fee. It is a little bit like a revenue-related rent in the like hotel business, where the landlord often wants to benefit from a good revenue of a hotel in a top location. There you find this also quite often. The idea behind that royalty is quite simple. The more the licensee benefits from the IP that the owner of the IP has created, the more profit will be shifted to the licensor. At the same time, the licensee has quite few risks in the case there might be no return after using the IP. So the royalty is more or less a share of the expected benefit of the IP between licensor and licensee. They share opportunities, but they also share risks. And at the same time, running royalty is kind of an incentive system for the licensee to use the IP and to gain profits. Usually, a royalty is agreed on revenues achieved by the licensee while using the licensed IP. This is the typical revenue-based running royalty many have in their mind when they talk about licensing. There is many reasons why this license is so popular, But I think my time here is quite a little bit limited, so I skipped this aspect now. As each license fee model shifts risks and opportunities between the parties and has also an effect on the incentive system, how the IP is used, you find quite often a combination of both systems. Here, very popular is, for example, to agree on a fixed fee in the beginning of the license contract. This motivates the licensee to use the IP as soon as possible to cover costs quickly, and also a running royalty. So if the fixed fee is, for example, offset against the royalty rate-based fee, you encourage a licensee to use the IP at all. And if you then start to lower, for example, the percentage of the royalty rate dependent on the volume, you motivate the licensee to generate even more revenue. So the total amount of license income will increase for the licensor, and at the same time, the licensee can improve profitability. So we create a typical win-win situation. So Dana, now I come to the next slide. Thank you. I would also emphasize one thing, and this is what is the royalty base in the case of royalty rates, as those are very popular. Many have in mind that you use something like net sales. Well, but we in the economy, we do not have like net sales as an overall defined termination. In some cases, it seems to be quite easy. But in other cases, you have a certain a complex rebate system and also specific definition. So it is very important to define a meaningful item that shall be the reference base for royalty rate. Another important aspect is what is really the value driver for the IP you have licensed. In some cases, for example, if you take glasses you sell in shops under a well-known luxury brand, then it's quite obvious that the revenue you generate like with these glasses is caused by that very attractive luxury brand. So this is easy. But in many cases, it's not that easy to tell, especially if you have to invest know-how and a network to bring a product to the market. And the patents you might use are only one piece of several input factors. So in a nutshell, it is very important that a pure revenue royalty is not always the main value driver of the IP that is licensed. Well, I am quite often asked, what is now the right royalty for our industry? Well, I have to admit, this question cannot be answered. It is like asking, what shall I pay as rent for my apartment? For everyone, it is quite clear that the answer for this question will be, it depends. You will start ask questions back, like, where is this apartment? How big is it? Is it with kitchen or without? Is it with a garden? Do you have a basement? Does it have a fancy view? And all of these kind of important input factors. So to be honest, in the very simple way of leasing an apartment, it is very clear to everybody that there is not a single rent for everything. But in the much more complex situation, for deriving a payment for the usage of IP, it is expected that there's a simple answer, the royalty of an industry. And it is not. And it is not simple, it depends. It has to be, from my point of view, carefully calculated by considering several aspects. And those aspects were already mentioned by Eszter, as they are defined in the license contract, and they vary from contract to contract if it's exclusive or non-exclusive, if the market in Asia is included or excluded, and if I am obliged to invest a certain proportion of marketing or in know-how or in R&D as well. So finally, it depends on the economic terms of the specific license situations. Well, I have only would like to mention quite short the last aspect on my chart, the licensing with standard essential patent, the SAP, as this part is already it's also part of our business primer. The front licensing is a very specific topic. It refers to the standard essential patent situation, so it doesn't have to do anything else with brands or know-how. It refers to patents, and front means to offer a fair, reasonable, and non-discriminatory royalty. These conditions are relevant in the question to license, to be obliged to license these standard essential patents. Well, and in this context, it has to be somehow simulated what a fair royalty for a specific patent portfolio is. And most of the cases we have in these SEPs, in these standard essential patents, we have technology complexes that cause a lot of questions. What is really the value driver of the patent or the patent portfolio we talk about? So these types of licensing is for us like the high rank of calculation of fair royalty rates in often more the litigations cases, Esther, you probably know that, with highly conflicted situations between licensors and licensees. No, I will stop at this point and ask Dana to take over for the Q&A session.
Great, thanks, Anke. Appreciate it. I love the way the two of you both kind of led us through the publication. You know, there's a great chart, and Eszter, you talked a little bit about it in yours on the pros and cons. But you know, you both answered the question: why even bother with a license, right? Why even map out this relationship that you're entering into, and all of those factors, and frankly choosing the right partner. So all of those things are critically important. I wanted to get we've got a pretty active discussion on the Q&A, so we want to get to some of those questions, and we've got just a little less than 20 minutes to do that. Eszter, why don't I go back to you first, and help us understand what kind of problems may occur related to the licensor's right to license the IP. And you know, you raised the question before on you know, how can one check the ownership status? So can you talk about that?
Mm-hmm. Yeah, sure. I think the problems can arise mostly, at least what I have seen in practice, and mostly in my litigation and conflict practice. Two things. One comes from collaborations when the IP have joint ownership, and that is not always very clear, you know, especially in the very enthusiastic phase of creating an IP. That's very often the last thing people bother with. And then it's not clear who has the IP right. Maybe one of the owners thinks it's the owner, or the inventor, and there is also someone else. So in order to have your IP clear and neat for licensing or for any kind of investment, by the way, it's very important to have that clarified. And basically how you can do that is that you go back to the creation and you make sure that there is a very neat chain of title and entitlement leading to you when you are there to license the invention or the patent or any kind of IP. The other thing which is typical is when the IP is created in employment, because there are certain rules country by country relating to inventions and IP in an employment relationship. And for instance, in the field of patents, at least in the Hungarian law, but that is typical for many jurisdictions, in some kind of cases, the employer gets the right to the innovation by the force of law, but in some case it doesn't, and it has to do some specific act to gain the right to the IP. There was a very long litigation in Hungary, actually a few years ago, where where one of the companies thought that they declared to the employee that they want the IP. The problem is that they didn't do it the way the law requires them to. And like 10 years away, there was a huge dispute on who owns the IP. This was not a licensing case, but it illustrates, I think, the problems that can arise. And I think that the way you can check it is that, first of all, with registered rights, it's easier because you can first go to the public resources and you can check with trademarks, patent, registered designs. It's easier because you can check the status. It's also good to know whether the status that you think is corresponds to what you can see in these databases, for instance, the patent registers, because that's what other people will look at too. In the case of unregistered rights, I think the most you can do is that to have regular audits of your IP, ask someone professional if you have to, especially if you have complex rights, and have the paperwork clear how the right goes from the creation up to you. Great.
Thank you so much. Let's stay with you for a second, Eszter. I want to ask one of the questions that came in through the Q&A from Madeline Klein. So Madeline, thank you for the question. She says in her experience, you can't grant an exclusive license to Knowhow. You talked about the package of IP rights that you could put in within the license. So a critical part of that is Knowhow. Can you explain, do you think you can? Can you explain how you think through that and what license type to select in that case?
Okay,
I'm taking you off guard. We hadn't prepped this question.
Yeah. No, it's okay. No, it's just, I was just thinking that this format doesn't allow to ask Madeline to elaborate on her point of view. I think that if she means, or if we think that the know-how, you cannot help that somebody else develops the same thing. So the know-how is not like a patent where you shout to the world that I have this and nobody else should have it. The know-how is something that is kept in secret. And in that sense, I agree that you cannot grant exclusivity for something that you cannot ensure that nobody else has developed. But otherwise, from the point of view, and this is where I am saying, if I am completely off, then let me know, please. But from the other point of view, if I have a know-how, a defined know-how, and decide that I grant this right to you and no one else, I do not see the licensing difference between the know-how and other rights.
Interesting. Madeline clarified in the chat. She said not all know-how is confidential, I suppose, right? So I think it goes to what does the provision look like, and what's the extent of the relationship. So I think your point, Eszter, is detail that out. Make sure that you're very, very clear so that the parties know what they're sharing, what they're not. And you said clarity, because the lack of clarity leads to litigation, and I suppose then they called you and asked you to help. So Anke, let's go to you with a question. You talked about that whether there were typical rates for things and the difficulty of doing that. Well, is there, in your experience and from an economic point of view, is there a typical duration for licenses?
Well, we find in practice that there's not a typical duration for each industry or so, but you have to think on the one hand, the longer you have the duration, the more the licensee is willing to invest in the IP, because the period where you can amortize your investment is much greater, and you have time to use it and to come to the market. But the other problem is, as we discuss about economic terms in future, the longer the period is, the more uncertainty we have to face. So in this point, from economic point of view, you wish to have any chances to align a little bit, maybe a license contract. So this is always the field you're discussing, and to be honest, also this depends on the type of IP. And my understanding is that we do not only talk about typical patent licensing, but also know-how, or also like trademarks, or like whole bundles of IP or intangibles, because very often you find, like, to license, for example, also in the pharmaceutical sector that Eszter mentioned, you find like a combination of patents and know-how and documentations and, well, results from trials, etc. So it depends, to be honest, again, on the situation.
Yeah, there's that answer again. It depends. Every situation's a bit different, but that's why these things are fun. Okay, again, from an economics perspective, do you have a list of kind of do's and don'ts that you talk to people about as they're entering into licensing agreements? And what are your top couple?
Well, I start with the don'ts, and I think I made this clear in my short presentation.
Mm-hmm.
Don't hang on like industry standards, and don't use only like one discipline. I believe it's a very interdisciplinary process, which means that patent attorneys, lawyers, and also economic specialists come together from the business side to elaborate here a license contract where all these different disciplines have to be part of. And well, the do's is, from my point of view, to analyze the situation carefully and to try to like make a projection for the next years and calculate carefully from different points about the expected benefits like cash flows, and also to have the risks in mind.
Another question that came up from the Q&A was on forced licensing, typical situations. Eszter, I don't know if that's your question, or Anke, if you want to just address that.
Well, maybe both, because I think I also do a lot of litigation, and maybe Eszter can start from the legal point of view and I can add something from the economic point of view.
Yeah, I think if that is meant by the question is that when I was talking about my slides, I was mostly talking about the active licensing effort. So when you want to license and you look for a licensing partners, but licensing can arise from the situation when the IP is already infringed. And that means that you use the license as a settlement. That's how you solve the issue. When you are in the position of being an IP owner and you are in an infringement situation, you have two choices, basically. Do you want to protect your market? Do you want the others out from the market? Or is it better for you to offer them a license? If they take a license, maybe you are getting better off with that. That's a different negotiation position, even though it will overlap in many of the contents with what we just said. But it's partly the aim is there that you do not want to let the two parties get back into litigation from where they are starting from. So this is why I'm saying that there is a defensive part in that, but the license agreement can be a good way to settle a litigation as well.
Anke, did you want to add to that?
Maybe from my point of view, in cases of litigation, very often you come in the situation where you have to discuss about a fair and reasonable royalty. And in this situation, it's like that we try to simulate a negotiation and review both sides of the parties, like a licensor and a licensee, and also for sure to assume a willing licensor and willing licensee, and to skip the idea of to be forced to use the license. I assume as the information in the market, what is a typical license does not really exist. Again, it's very important to analyze in the specific case and to see what is really like the benefit of the usage of the IP and the usage in terms of what does the licensee really takes out of what kind of like cash flows or benefits when he uses like the IP portfolio?
I think we have a few more minutes for questions. Eszter, you talked a bit about certainly infringement. I hope the importance of talking about that in advance and potentially addressing that in the license agreement. One question is, what are the considerations for licensing after IP's been infringed? Can you license IP after it's been infringed?
That is basically the same kind of concept which we were discussing, because you may be in a situation when you are not actively looking for licensees for whatever reasons, but when the license is infringed and you are faced with the dilemma what to do, you have to as a potential plaintiff, as a right holder, consider your financial resources. Do you have the right money to do litigation? What do you gain with that? Maybe you are better off with a licensee. It depends on your policy, because as Anke just referred to, it makes a big difference if somebody is willing to license or if doesn't. At least as far as I have seen in my practice, it never started that somebody totally unwilling to do license ever resolved the conflict by entering a license. So there always has to be some sort of commercial reality for licensing in order to have that as a really eligible and viable source of solving the conflict. But it is possible. The fact that your IP was infringed by someone doesn't mean that you cannot fix that situation by licensing.
Yeah.
And so sorry, most importantly, you may want to get license free from the past use, of course.
Absolutely. Well, and it occurred to me while you're going through your presentation. I mean, it's worth just repeating. What do you have with an IP right? But you have the ability to keep others from infringing, others from using it during a period of time. That is your exclusive right. So exercising that enforcement, or at least monitoring that and communicating that you wish to protect this, that's part of managing and protecting that right. And that's frankly part of the value of that right. So, all critically important. We get an interesting question about, what you would tell digital startups that tend to overlook the possibilities of IP protection and licensing. They often defend their attitude by referring to fast-moving pace of technology development. But even they should consider a license. How would you argue to them that they're better off by taking that time versus rushing to further their business model? Why is it important to have both? How would you advocate? What would you tell that digital startup that says, this isn't all that important?
I would say that there are certain fields of industries and invention where I think that having your IP in place and having be able to have your IP identified and licensed on the long run may give you better benefits than rushing them. And all the risks that I have mentioned, typically what I see is mostly about ownership, is that, we just don't care because we are rushing. We want to get this done very quickly. And then there we are. And we realize later that the IP is infringing on something. The trademark name is just not good and you have to rebrand. There are a lot of things which I think are more painful afterwards than thinking about them in the beginning. Although I understand that for digital startups, this is a valid issue to think of. Which
Certainly.
is
well, and another point that one of the folks on the chat just said too, digital assets are hard to license in the long term. But the same thing can be said about licenses. It says for just protecting your IP and identifying what you want to protect early on. It'll pay dividends at the end, depending on what you end up doing with your company, what you end up doing with that invention. So.
I just can emphasize what Eszter says, because from our experience, especially with startups, they just want to move and rush and set up their business model. But still, these companies are complex in their also legal structure and and also like tax structure. And this also includes IP. And very often, because of the speed of the development, it's very dangerous to forget about these things, because the law is relevant for any company, even if it's a big listed company or it's a small startup. So I know it's a little bit nasty to spend money on that, but I know from my own experience that it's very hard if you have some deficits.
I would add one thing, maybe. Whatever you do knowingly. So the worst thing is that when the negligation of IP protection and IP rights comes from not knowing about them, it can be a decision not to protect something or not to license something or decide in favor of time and rush. But it's better to know what you are doing than realizing it later.
Yeah. I think that's a good point to end on. I mean, as you said, both of you, important for any company, maybe even more important for the small entity. But it's better to know what you're getting into. It's better to map all these things out in advance. And again, I encourage everyone to read the full publication. We've just given a little bit of a taste here with Eszter and Anke's help. So thank you both very much for your help. And I think our job is now to turn it back to Claudia to close out the session.
Thank you, Eszter, Anke, and Dana. This was a fantastic presentation. To all, please visit our website to register to our forthcoming webinar on the value of standard essential patents and the level of licensing. As explained before this presentation, a recording will be made available on 4IP Council's website tomorrow. And later on today, you will receive an email inviting you to complete a 1-minute survey about this webinar. And we will be very grateful for your feedback. So thanks a lot for listening. Stay safe and goodbye to everyone. And register for our next webinar on the 28th of January. So thanks to everyone. Have a great week.
Thank you.
Everyone.
Bye.
Bye-bye.